Right, and Eric, I think you can kick things off whenever you're ready. I'm sure we'll still get a few people who are still joining, but I think it's a few minutes after 2, so we can go ahead and get started.
Okay, wonderful. Well, so I think I recognize a number of these names, so I may know some of you, and just really appreciative of folks sort of joining in. And we're hoping to make this as informal as possible. So if people are willing to ask questions along the way, we'd love it, both in the comment section or just orally. I'm probably not going to linger because you are in extremely good hands with Jen LaValle and Tom Papson. But I figured I'd just sort of welcome everyone to this sort of part of our summer series, and with a little bit of like a deeper dive into different issue areas at Legal Aid. Jen LaValle, I know I claimed I would introduce you guys, but I did not re-look or refresh my recollection about either of your bios. And Jen, have you surpassed the 10-year mark at Legal Aid? Or no?
I have. Last year I surpassed it.
Okay, well, Jen LaValle came to us as an AmeriCorps volunteer from a law firm to work on consumer law issues. And I think it may or may not come up that our consumer unit has really grown. And I think in part has grown because of the success of this Making Justice Real campaign that's happening over the summer at a lot of your firms. From what it was I think just 2 people then to a bigger unit now that Jen can talk about. And then Tom Papson has been a long time, was a board member, board president, was a managing partner of McKenna, and has been now at Legal Aid for a number of years, virtually full-time, sort of technically part-time, but experientially full-time, and I think close to more than full-time post-pandemic. The pandemic has caused sort of a massive amount of work, at least with respect to sort of policy advocacy that Jen and Tom may be able to talk about, both at the DC Council level, at the DC government level, and with the courts to try to influence them to open as safely as possible and responsibly as possible. And then preferably to open, the mayor has been saying we want DC to emerge as a more equitable and a more racially equitable DC. Currently, that is not happening. Currently, DC is, I think, managed to be less equitable right now and less racially equitable than it used to be because of the extraordinary disproportionate impact of COVID-19 on our client community. But our goal and our aspiration is to really push the court and the government and policymakers to have that be true, that somehow we will improve access to justice and improve the legal systems coming out of this crisis as opposed to the other way around. So I am going to drop off. Hopefully I set an example by being willing to chat so that some of you on the call are willing to ask questions if you have any or observations. But I'll turn it over, I assume, to Jen LaValle, who's probably the first person to talk here. And thank you all so much.
Thanks, Eric. And Caroline, why don't we go ahead and advance to the next slide. Thanks everyone for being here. We're excited to take this deep dive into the consumer law with all of you, starting with explaining what consumer law even means. That's a term that can mean a lot of different things to different people. And so we want to take this time to get you oriented with what consumer law means at Legal Aid and why that has become a new and growing practice area within our organization. We want to tell you a little bit about what our debt collection defense work looks like during the pandemic, what our foreclosure prevention work looks like during the pandemic, and also the role that pro bono services play in all of our work. Tom and I both come to Legal Aid with a law firm background, having been there before we came here. For me, before I came to Legal Aid, I was a law firm co-coordinator for the Generous Associates campaign at my firm, which is now the Making Justice Real campaign, and found it to be a really interesting and energizing way to learn more about what legal aid work was about in a non-generic way. And so we're so appreciative to all of you for being here and wanting to take this deeper dive into what our work looks like. So we'll want to talk about the role of pro bono services and what we do today as well. All right, let's go ahead and we'll advance to the next slide. And actually even one more. So what does consumer law even mean at Legal Aid? The main thing that we're trying to do is protect the limited income and assets of low-income DC consumers. And the main way that we do that is through direct legal services. We focus on debt collection defense and foreclosure prevention. Now, I want to start with just a question to all of you, if for anyone who's willing to enter something into the chat. So please type in your answers if you can think of some. But what are some of the reasons why you can imagine that a low-income person who's been sued for a debt or who's been sued for foreclosure might not come to legal aid on their own to ask for help? So if anyone can just enter in the chat box, things you might think of, why someone doesn't just call up legal aid or come to our office looking for a lawyer, even though they are at the point that they actually have a court case with one of these things. So I'm just going to read these as they come in. Lack of knowledge, not a lot of faith in the system. They might be intimidated, feeling embarrassed. So sort of a lot of barriers, emotional barriers, time barriers. These are great. Keep them coming. Income qualifications, either not meeting them or fearing that they don't. I think and keep them coming. I'll sort of start talking a little bit more about this, but I think the things that you all are entering are absolutely on point, and we see sort of a whole range of reasons why people might not come to legal aid on their own, but desperately need services from a legal aid lawyer. These barriers that people are mentioning, whether they are emotional barriers or barriers like money and time, needing to get on public transportation, maybe living in an area where you don't have access to a lot of transportation, having to take time off from work, needing childcare. The Community Listening Project was a study done, a qualitative study done in DC just a few years ago, and found that for a lot of issues like, for example, debt collection, folks who need help with these issues don't even necessarily see them as legal problems, might see them as financial problems and problems of hardship, but the kind of thing that, like, how could a lawyer make a difference? I just don't have money. And so there can be a combination of these very real sort of money barriers, time barriers, and also thoughts about the way someone has conceives of their problem as not necessarily being a legal problem. And for all of these reasons that you've mentioned, that we have these last two bullets on the slide, which are, in addition to our just regular direct representation of, taking on a case for someone who walks into our office or gives us a call, we have these court-based projects and systemic advocacy that we do. The court-based projects mean meeting our clients where they are, literally, right? You hear that all the time, meet someone where they are, start with where they are, but we mean it literally, in that we will place our attorneys at the courthouse. We will place ourselves in the courtroom where the initial hearings in debt collection small claims cases are all held sort of in bulk. We'll place ourselves in the courtrooms where the foreclosure cases are consolidated when they first get started. And we will place ourselves where people are at critical times in their case, which a lot of the time means at the outset, but also sometimes further along procedurally. And at a time when folks need us the most, because in addition to all the other barriers that people have been listing in the chat box, there's also this issue that if you're a low-income person struggling with a debt problem or a foreclosure problem, you are probably struggling with a whole mix of other problems, and you're needing to prioritize what is the most urgent and kind of deal with things in the hierarchy of urgency. And for a lot of folks, it might mean that getting yourself to court is the critical moment. And if you can do that, that's the extent to which you can handle this case right now. But at every moment up before then, you're needing to focus on other more urgent things that are also competing for your time and energy. So our court-based project means placing attorneys where litigants are on their court dates, available to enter into same-day limited representation, and then to extend it beyond that in appropriate cases, and to sort of eliminate extra trips, extra barriers for folks to know that we're available. And then the last bullet point is systemic advocacy. And this is talking about folks who are in our client community, but who maybe never become our clients. This is talking about working with the courts or administrative agencies, the DC Council, and trying to use our experience providing direct representation and what we've learned from that to work on more systemic changes, whether they're changing the laws or the rules or court forms and operating procedures to help folks who don't have an attorney, people who aren't represented by us, people who might never make it to court, looking at the way that default rates work and looking at whether forms are accessible and understandable to a lay person who doesn't have an attorney. Okay, why don't we go ahead and advance to the next slide. Oops, sorry, I did that too early. You can go back. So the last thing that I'm going to talk about is just what a typical day looks like at Legal Aid, because I think that can help sort of clarify what we're talking about here. So I'm going to talk about what a typical day can look like as a foreclosure attorney, and then I'm going to turn it over to Tom to tell you a little bit more about what a typical day might look like as a debt collection defense attorney, since those are some of the subspecialties within legal aid. In foreclosure, our court-based project is having several attorneys placed in several simultaneous courtrooms in DC Superior Court every week, where the cases that are filed by mortgage lenders are consolidated. DC Superior Court has set up a very pragmatic system for addressing the foreclosure problem in DC, where rather than going straight to the legal questions of, did you have a mortgage? Did you default on your mortgage? You know, what does the contract say? They've built in almost like a diversion program on the front end, where instead of skipping straight to the legal questions, it encourages the parties to look at the practical questions first, which is, okay, there may well be a default. We'll deal with that and any legal issues surrounding that later if we have to. But if you live in your home, if you're trying to keep your home, if you're hoping to work something out with the lender and you haven't been able to do that yet, let's try again if you want to. Let's use this system with kind of an overlay of court deadlines and supervision to help you apply for a loan modification or some other type of restructuring of your mortgage. Maybe it'll go better this time because now you can meet with a lawyer who's right over there in the back of the courtroom, and you can meet with a housing counselor who's right over there on the other side of the courtroom, and try to see whether with a little bit of extra oversight and structure on the process, there's a way to get you back on track, because if so, then maybe we will never need to get to the legal questions. And maybe even if you don't qualify for a loan modification right away, if maybe when you meet with these lawyers, if it's right on the edge and you meet with one of these lawyers and it turns out there's a legal issue with your case too, maybe you can still work something out that wasn't possible before. And so, you know, a typical day in the life of a legal aid foreclosure prevention lawyer is staffing those court-based projects, doing intakes in court, providing limited representation in court, extending that representation to take on fuller representation cases. And it's looking at cases with both a practical lens and a legal lens. So we're doing a lot of looking at our clients' financial situations and their loan balances and trying to see what kinds of restructurings of their mortgages might work to preserve pretty rare pieces of affordable housing when we find them, and also screening for legal issues, looking for indicia of predatory lending, looking for abuses by mortgage servicers. Maybe not everyone's following the rules about how to credit payments or how to how to communicate with borrowers who are trying to get help. And so it's kind of a mix of in-court work, out-of-court work. It's a mix of practical number crunching and legal issue spotting. And so with that, I think I'm going to turn it over to Tom to tell you a little bit about the day in the life of someone who's focused on the debt collection defense side.
There's a lot of similarity on the debt collection side with what Jen just talked about on our foreclosure practice. As with foreclosure, we have a court-based project, which means we have lawyers in the courtroom for the call of the debt collection calendar. There's another organization in DC who also, another legal services organization that also has lawyers in the courtroom. So on a typical day, pre-pandemic, busy courtroom could be more than 100 cases on the calendar. There may be as many as 5 or 6 legal services lawyers there ready to provide immediate advice or limited representation, same-day representation to the defendant. What characterizes the debt collection court, and this is true in the foreclosure court as well, is that every plaintiff who is suing on a debt has a lawyer. They're required to have a lawyer to be in that calendar. And virtually no defendants have lawyers before they show up at court. A small number find their way to legal services or some other representation beforehand, but most don't. So over the years, we've developed a pretty efficient system for letting people who show up know that we're there and we're ready to help, and why they might want to talk to a lawyer, and for connecting with us on the spot. The kinds of debt that are on the debt collection calendar in the Superior Court, it's pretty much what you would expect. It's a lot of credit card debt, and then there's everything else, which things like medical debt, homeowners associations suing for their monthly fees that haven't been paid. It can be a tenant who's moved out of an apartment and the landlord claims the tenant still owes back rent. It can be a direct internet purchase from a retailer who's providing credit directly. It can be all kinds of things. What do? We try to size things up with the person who's asking for assistance as quickly as possible. We take a look at their court papers. And what can we, you may be wondering, what can we possibly do for somebody on the spot on their first day in court? Sometimes it's a matter of figuring out that this defendant has no income that a creditor could possibly touch, which we call protected income, exempt under law. And for those people, one of the things we do is help them request and support a request for what we call a hardship dismissal. If that person doesn't have a lawyer, what might happen when they go through the process in court, and debt collection court in DC means a mediation to attempt to settle the case first day, what might happen to that person is being talked into entering into some kind of payment plan on their debt under which they pay a number of dollars a month, which they A, can't afford, and B, probably makes no sense to agree to pay because a judgment would do the creditor no good anyway because they only have, for example, Social Security income or disability income. At the other end of the spectrum, some cases we size up and we immediately see there's potential defenses. It could be a case of identity theft, which comes up all the time with credit card debt. It could be a question of whether the plaintiff suing this defendant actually owns the account and the debt in question. There could be other indicia of fraud. There could be straight contract defenses. So we size all that up and try to take some action right away that's going to advance the ball on getting the case resolved. It could be the hardship dismissal approach I mentioned. It could be assisting the person in negotiating a payment plan if they want to settle and they don't have defenses. But in the other cases, and these are really, for us, the most interesting cases, it's taking that potential defense and running with it, which often means getting a continuance and potentially offering that defendant fuller scope representation beyond the first day. I might also mention one other type of service that we provide in debt collection court, and that is that there are a lot of default judgments. Too many. It's a sad state of affairs. It's true in our court. It's true across the country in small claims kind of courts. High level of default judgments, and many of those default judgments, not all, but many, are because there was improper service. So when we encounter defendants that are in court because, for example, their wages have been garnished because there's a default judgment they didn't even know about, we can take those cases as well and try, if appropriate, to get the default judgment vacated. So that's another kind of service that we regularly offer in debt collection court. Jen, I think that pretty much covers it. Unless you have anything to add, we probably can move on.
Yeah, no, why don't you go ahead and move on, and you can give an example of what, one type of debt collection case could look like or did look like.
Yeah, so you're looking at tender Richardson. Sure.
I'm getting some feedback. I'm trying to, might it be possible to maybe, let's see. We can mute and then unmute, or try just plugging in the headphones again. Tom or others, are you also hearing feedback?
I'm getting that. Yeah, maybe you could just ask your question in the chat, and if you can put it in the chat, Jen can take a look at that while I'm talking.
I can do that.
Oh, although it is fixed now.
Okay, so you're looking at a slide with a photo of my former client, Kendra Richardson. And this, her case, the case I handled for Kendra, was a very typical example of what we sometimes refer to as a back rent case, where the tenant, often driven from her apartment by adverse housing conditions, moves out perhaps before the end of their first year of a one-year lease, and the landlord takes the position that the tenant owes the rent for the months remaining on the lease, or at least until they re-rent the apartment. Ms. Richardson was, in her case, she was driven out of her apartment by a bed bug infestation, as well as an infestation of vermin. She had tried to work with her landlord for months on end to address those issues, and cooperated with all the requests the landlord made for her cooperation in addressing them, to no avail. When we investigated the case, we found out that on top of that, the landlord was unlawfully charging her excess late fees that were not permitted by law and regulation. So there was a lot going on there. And in most of the cases we handle in debt collection court, once you've got some defenses of some merits defenses, generally speaking, the plaintiff is on the run. They're in small claims debt collection court because they're looking for a quick judgment. And when there's a lawyer involved, and when they see that there's credible defenses, the tide often turns. And it did turn in this case. I'm happy to say that eventually we filed a counterclaim. We settled the case, and we got a monetary recovery for Ms. Richardson to compensate her for not only the late fees that she had been improperly charged over time, but her other dislocations as well. So happy ending on that one. And it's one of those cases that you just love to handle and love to get a good result in.
So thanks, Tom. One of the questions that we got from David on the chat is how amenable are the creditors' counsel to trying to work out cases with us and with our clients? And I want Tom to chime in on here as well, since Tom is on the ground more than most. But I think, on the whole, I would say that they are very interested in working cases out, and where the big question is in what way. The creditors' counsel or the debt collection counsel are there for the purpose of cutting a deal, especially if you look at the way that small claims court works in DC, and small claims is generally defined as claims for $10,000 or less jurisdictionally. The very first thing that happens when you come to court before the judge deals with anything legal in your case other than service of process is they send the parties to mediation. And frankly, I think that's why these cases have been filed, because the plaintiffs are looking to collect. The issue is that, are these settlements going to be the fairest settlements that they could be, even for a defendant who does want to resolve the case in that way? And so I think what we've observed is that the creditors' counsel or the debt collection counsel come in with some set parameters of guidelines that they can offer settlements for, right out of the box. I'll do monthly payments of this amount, but I can't stretch it out for longer than 24 months, for example. And for some defendants, that would be fine. And if it's a really, really cut and dry case, they might actually walk away sort of happy with a regular out of the box deal that they can cut. Where a lawyer really makes a difference is when you find all those extras, the things about the underlying transaction that were unfair, or the things about the person's hardship situation that makes it such that it really shouldn't be an account that they're paying on for the next 10 years, where it takes extra, either in the way of negotiating or digging into the fact history or the legal issues to get a settlement that is fairer, or to say, actually, this is a case that should not settle. Tom, anything you would add to
No,
that?
I think that covers it.
Okay, that's a great question. Thank you. And keep them coming, everyone. I have another question that I think might have just come to me, but I have one question that's asking whether attorneys from law firms ever assist legal aid with representation in these cases and maybe day of representation. Right now, it's not typical that we have pro bono attorneys involved in the same day representation, other than through the model, you know, where Tom has become a legal aid staff member. But we do have law firms get involved in these cases from time to time. One thing that we run into a bit more in consumer than we do in other areas is the issue with conflicts of interest, just because so many of our cases involve financial institutions on the other side, either directly or in sort of like the chain. And for some firms that poses a bit of a conflicts issue, for others it doesn't. So it's just, it becomes a little bit more of a case by case basis kind of question. That being said, there have been a lot of pro bono opportunities that have stemmed from these cases, even if not necessarily for the day of representation. What's more likely is that we are there through our project to find the case day of, to intercept to day of, and then we learn about it and we say, whoa, you know, there's a real insurance coverage issue involved here. We really need someone who's got some expertise in insurance coverage issues to help us look at this. Or wow, there's we got this great settlement. We think it's a great settlement, but there could be some tax implications, and this person is getting benefits, and we need to know what the implications are going to be for their benefits and for their tax liability. And so there are a lot of offshoot pro bono needs that stem from these cases, in addition to having some of them just be cases that we can place and do place directly with law firms, even though we're usually the ones who will do the initial intercept. That's a great question, and please do keep them coming. Caroline, I think we can advance the next slide now. All right, so Tom, I'm going to turn this over to you to talk a little bit about what our debt collection work looks like now, really in the pandemic environment, and some of the things that Legal Aid has been up to. You can advance the next slide again.
Yeah, so what we've been up to is a lot less of what we just talked about, and in fact, really none of what we just talked about, because the court has gone to remote hearings and is being selective about what cases it actually is currently hearing, and it is not currently hearing cases on the debt collection calendar. But that has not left us looking for something to do, because as Jen suggested earlier, the pandemic created its own new set of needs for advocacy in the debt collection space. And so Legal Aid, and particularly Jen and myself, and we have a policy director, Damon King, who have been very involved at the council in debt collection related advocacy. The bottom line is that the DC Council has adopted emergency legislation under which no new consumer debt collection cases can even be filed during the period of the emergency and for 60 days after, which right now takes us to September 22nd. And importantly, it also provided that writs cannot be issued. So one of the things that we give high priority to in our debt collection practice generally is the situation where, again, often following a default judgment that the person knows nothing about, all of a sudden somebody's bank account has been attached or their wages have been garnished. So the emergency legislation that we advocated for includes protections and prohibits consumer debt collectors from having writs issued by the court. Automobile repossessions were also stopped because of the protection for not issuing writs. As a practical matter in DC, unlike some other states, the stimulus payments, checks or bank account deposits can't be seized except for child support rearages. So that's been a real roller coaster, and for me, it's been a real eye opener about how the legislative process in DC can gear up and work on a highly expedited basis. Separately from that, we've been involved recently in advocating for a new, the title of the introduced bill is Debt Buying Limitation Act, but really what it is it's a modernization of DC's ancient and obsolete debt collection law. Like many states back in the 70s, when credit cards were not the only game in town and many retailers provided credit directly, DC and most states adopted special debt collection laws geared to retail installment sales. And unfortunately, here we are in 2020, and DC's law, pretty much like it was enacted by Congress before Home Rule in the 70s, is still on the books. So this law we're advocating for and trying to get on to a hearing would both modernize DC's debt collection law to make it apply to most consumer debt, including credit card debt collection. But importantly, in addition to that, other features of the bill would introduce substantiation requirements so that debt collectors, when they're attempting to collect the debt, would have to have certain information in their possession about the debt and the account. And when debt buyers, companies who buy consumer debt and then sue on it, when debt buyers go to court, this bill, if passed, would require them to have particular information and plead particular information in their lawsuits. And I'll just say one other thing about that before turning it over to Jen. When the public health emergency ends, whenever that is, and whenever all this emergency legislation ends, whenever that is, there are going to be huge impacts on low-income communities, especially communities of color in DC and elsewhere. Those impacts are going to be felt right away in foreclosures, in tenant evictions, but also in debt collection. So one of the pitches we're trying to make to the council to get them to give this bill some priority is to say there is going to be an avalanche of debt collection cases post-pandemic, not only because there's going to be a lot of people owing debts, but importantly because collection of debts in many respects has been put on hold for many months. And DC really needs, the consumers really need the protections of this act before that happens.
Yep. So just to piggyback on what Tom was explaining, we've been focusing on everything on that left column right now, the legislative activity. But one of the things that we know from practice and our sort of what it looks like on the ground is that legislation is almost never enough. You also need sort of some of these operational things to evolve with legislation in order for it to really work for the people it's intended to protect. And so we worked like crazy for the first several months of the pandemic just to get this emergency legislation in place. It was multiple rounds of emergency legislation at the DC Council and all the lobbying that goes along with that. But once we got it, the next big push was to work with the court to make sure that the court's operations would somehow match the emergency legislation. So for example, the DC Council can say you're not allowed to file these lawsuits, if you fit these criteria. But if a bunch of debt collectors do it anyway, and then we have to find all of those defendants and help represent them and to make arguments to, dismiss those cases, that's not only taking up a lot of resources on our end that could be used working on other things, but it's also really putting defendants in harm's way of thinking they have to travel to court, thinking they have to answer complaints, getting scared about the existence of a court case and entering into a payment plan, even though the case should have never been filed to begin with. And so one of the things that we have been doing is working closely with DC Superior Court through a working group to say, now that this legislation is in effect, what kinds of general orders or other administrative steps can the court take to stop these things from being filed in the first place, or at least to say, what, in light of this legislation and in light of some of the operational efficiency and public safety things that we need to be bearing in mind, let's just decide that there's a whole category of cases that we're going to automatically continue during the period of this public health emergency and for 60 days. And so one of the big things that we've been doing sort of as a piggyback to the legislative advocacy is to try to get operational things at the court to match, so that even folks who have no idea that this legislation exists on the plaintiff side or the defense side will still get the benefit of those protections. The other thing we've been doing is planning for the remote hearings, which are getting started in other areas and will get started in debt collection probably later this fall, and doing outreach to reach people before they necessarily have to come to court, because for those who actually are in a position to resolve a case, why not help them do it now before they ever have to come back? And we've also been planning for the launch of a DC debt collection defense hotline with a partner legal services organization that'll provide a single point of entry, just one phone number that can be placed on court notices when hearings get scheduled again, that people can call and talk to an attorney on the spot, hopefully get some advice on the spot, and also get representation wherever possible. This leads me to one more question I want to encourage people to put some answers into in the chat box. We're talking about remote hearings and trying to get ourselves and our clients ready for remote hearings as they start increasing on all of the different calendars that we practice on. What are some of the positives that you can think of and some of the negatives that you can think of that might come from hearings being held remotely, meaning by video or phone, when ordinarily they've all been in person at the courthouse? So we're looking for positives and negatives of having court hearings held remotely. And I'm just going to read them as they come. One negative is lack of technological expertise by defendants. Yep. Other negatives I think are related to that might be access to technology, the digital divide, access to phones, computers, internet, maybe having a computer at home but needing to let a child use it for school, things like that. Language barriers. We've got a lot of clients who are limited English proficient or non-English proficient, and needing to have live interpretation just adds a whole additional layer of complexity to a remote hearing, or might just deter someone from feeling like they're going to be able to do it. Any positives that people can think of that could come from having hearings remotely when they've traditionally all been in person? Oh, I see one now. Positive, not necessary for defendants to deal with transportation difficulties. Absolutely. Public health, right? I mean, for a long time, I think we were really worried that the court might just open up way before anyone thought it was safe to do so, and have these crowded courtrooms with large calendars and large dockets. And thankfully, that is not the way that the court has been trying to phase back to its opening. And efficiency too, we've talked, it's almost like the opposite side of the coin from those barriers that we talked about earlier, why someone might not reach out for assistance from legal aid. Well, why someone might not come to court? Maybe it's just too hard to get there. Maybe there are scheduling difficulties because you have to end up taking a whole day off from work for what ends up being a 5-minute hearing, and you just don't know when your case is going to be called. Maybe there are childcare issues. There are a lot of barriers that come with having to physically come to court too. And so I think what we've been trying to see, through our work at Legal Aid is both the need to work with the court to be really thoughtful and careful in the way that it has remote hearings, while also hoping that there are some real positives that can come out of this. And going back to what Eric talked about with Mayor Bowser and saying, this is a once in a lifetime opportunity to build a more equitable DC, looking at this as a really critical place to implement that concept. I'm seeing more negatives here, added difficulty in credibility determinations. Absolutely. Any kind of evidentiary hearing done remotely is a very different story. How do you get evidence in properly? what kinds of bias might seep in if you can see what's going on in the background of someone's house, you know, especially if you've got like let's say you've got a housing conditions case or something like that where your surroundings are actually relevant to the case, how difficult it would be to do mediations. Yep. I don't think Tom or I have had one yet, but we've definitely been thinking about it and trying to think about how do we have those private sidebars with our clients that are so important, and how do we navigate some of this stuff that we've grown accustomed to how it works in person. So I think the court is really trying to be responsive to these concerns, but there have been a lot of them, and that's been a big part of our work in terms of systemic advocacy.
Yeah, and the court is doing remote mediations in the cases that are in the group of cases that are going forward. They are starting to arrange for those, but as Jen says, there's some real logistical challenges there, especially with, you know, being able to consult with your lawyer. I might also just quickly mention that one of the things I've learned through this process of trying to help deal with the remote hearing problem is that there tends to be an assumptions made by well-meaning people that hey, everybody's got a smartphone. What could the problem be? Well, turns out just having a smartphone, assuming you even have a smartphone, is not the solution to many of these technological barriers with something like a remote hearing. You may not be able to do a WebEx video on your smartphone, especially if you don't have the latest, highest level smartphone. So huge problem that courts here and across the country are wrestling with.
Yep. Caroline, if we could have moved to the next slide, that would be great. And actually one more after that. So I'll tell you briefly what's been going on the foreclosure side during the pandemic, and then just keeping an eye on our time, I think we'll wrap up by telling you a client story that involves both legal aid and the involvement of pro bono counsel. Just like in debt collection, you know, the first several months of the pandemic at legal aid were spent just doing a ton of work on legislative advocacy with the DC Council, trying to protect people from losing title to their homes while they were subject to a stay-at-home order, while people were out of work, while we were trying to keep people from going outside for health and safety reasons. And what we ended up getting was something that's somewhat similar to the debt collection restrictions. Not only are the foreclosure auctions themselves barred during the period of the district's public health emergency and for 60 days after, but the filing of new cases during that period are also prohibited. And, you know, there are some limitations. This applies to owner-occupied properties only. Investment properties are not covered. Commercial mortgages are not covered. This applies to foreclosures that are due to a default on the mortgage payments, and it also applies to foreclosures that are due to non-payment of condo fees. It applies regardless of whether the foreclosing entity was planning on foreclosing on you through the court system or using DC's non-judicial process, both of which are legal. They just have their own separate procedures. So it is quite a broad protection, and it was something that we really needed, because in the very beginning of all of this, we were still seeing foreclosure auctions being scheduled at the major auction houses. And incrementally, we started seeing them get pulled off even before the legislation was passed, because the mayor's order on non-essential business was sort of creating a little bit of foreclosure protection as a byproduct of that. But we needed to do a lot of advocacy with, you know, for example, OAG, trying to say, like, here's how we read the mayor's order. Do you agree? We don't think that these auction houses should still be doing these auctions. And then we were able to get something much more explicit and clear and intentional to protect homeowners from the DC Council after several rounds of emergency legislation after that. There's also mortgage payment relief. You might have heard a little bit about this in the news. Of course, there's the Federal CARES Act forbearance, which means if you've got a federally backed mortgage, Fannie, Freddie, FHA being some of the big ones, but not the only ones. And if you're experiencing a hardship due to the pandemic, you are supposed to, without a whole lot of barriers, be able to contact your mortgage servicer and get initially up to 180 days of mortgage forbearance. That doesn't mean you don't owe the payments, it's not a forgiveness, but it is kind of a pressing pause on the obligation to make your monthly payments, and no interest is supposed to accrue because of that. And then it can be extended for another 180 days so that you essentially have a year if you're continuing to experience hardship. DC does not have its version of that. I mean, it does, but it's much more restrictive. But it's the same idea that if you are experiencing a hardship due to the pandemic, depending on what type of loan you have and with exclusions, you can ask your servicer to give you a forbearance that can be either a partial or full break from your monthly payments during the period of the forbearance. And that just is meant to help people have a little bit of breathing room while folks are out of work, and before things start to look normal again, which I think it's going to be a really long time. Again, as with any legislative advocacy, you can't stop there. We need to be working with our court system to make sure that the on-the-ground reality matches what the legislation is trying to do. We're part of a working group with other legal services organizations, housing counselors, and bank attorneys to try to work with the court on crafting a similar administrative order on how to handle the bulk of foreclosure cases in light of this legislation and what it prohibits and what areas are gray. We are doing a lot of outreach right now. We've got pro bono help, culling the public records and looking through the dockets to get information that'll help us issue spot for folks who we think might qualify for CARES Act forbearances, preparing outreach letters, trying to do all kinds of things to let people know we're here to assist and really try to connect with homeowners, even though they don't have, for the most part, hearings going forward right this second. There is a limited set of foreclosure hearings that are starting to go remote. Thankfully, our understanding is that they're not moving forward to judgment and foreclosure, but they're the hearings that are occurring so that we can connect homeowners with legal services and housing counselors through sort of what has become our remote version of that same court-based project that we were describing before. We're really trying to mirror that as much as possible. We have access to these WebEx hearings, so we can just log on and be there, even though we don't necessarily have a case or a client. We can be there so that if someone is interested and willing to talk with us, right after their hearing, or says to the lawyer, to the judge, I need help, the judge hopefully will give them a continuance and connect them with us as close to as on the spot as possible so that we can then do an intake and see whether we can offer representation and help them figure out a resolution. Okay, so let's move on to the next slide. Let's do one more. I'm going to tell you, we'll close out by telling you a story about a client who is very dear to our hearts, and both Tom and I worked with her, and she got help from a pro bono attorney as well. This is just to give you a sense of kind of the network of both problems and services that come up in these cases. This is Donna Williams. She's a former client of ours at Legal Aid. She had saved up for years to buy a home, her first home in Congress Heights. And she's a single mom. She's got a teenage daughter. And the night of closing, when she got her key, for anyone who's ever bought a house, that feeling, she got her key at closing, and they were so excited that they slept on the floor of the house that same night before there was any furniture, right? They hadn't actually moved in. They were just excited, and they slept on the floor that night. It was such a big deal to have been able to purchase a house. Unfortunately, not too much longer, she ended up falling behind on her mortgage. She had a blood clot in her leg, and it caused some unforeseen medical expenses that just threw everything kind of out of whack with her cash flow and the way that she was managing her expenses. And she hired a law firm. We didn't connect with her until later in her case. She actually hired a law firm that promised to help her avoid foreclosure, including through litigation, because she got sued by her mortgage company when she fell behind. But her lawyers failed to appear for her in court or to do anything in her court case. They just did nothing. She would get notices and pass them along to the attorneys and kind of trust that they were handling it. And what they were doing, in fact, was nothing. Without her realizing it, that led to a default judgment when no one appeared, no one filed anything. And with the default judgment, that means that the house goes to an auction sale. The first moment when she realized that something had gone terribly awry was when she got a little note taped to her front door. She's still living there, paying these attorneys. And she got this note taped to her front door from someone saying, you've got to get out. Talk to me about a move out plan because I'm the new owner now and you're living in my house. And she obviously felt panicked. And that was the moment at which she sought help from another lawyer and found her way to legal services, terminated her relationship with her paid lawyers. And basically at that point, we had this job of trying to figure out what on earth happened and how can this be unwound? You know, is it too late? Can we get her back into the position she was trying to be in the first place, which is getting back on track with her mortgage and staying in her home? Legal aid was able to help her in a few different ways. The first thing that we had to do was prevent her from being forced out of her home by the auction purchaser. They tried to file basically bogus eviction action that ended up being dismissed. What we had to do in the foreclosure case was file a motion to vacate the default judgment. There were a couple of grounds for that. One was excusable neglect when you looked at the sort of fact pattern of everything that happened with the lawyers who were supposed to represent her and didn't. But the main thing that we relied on was actually lack of service, because it turns out that she was never properly served. They had delivered the court paperwork to her mother at a house that she didn't live in. And so there's a long evidentiary hearing about service of process that thankfully resulted in the judge finding that there was no service, and that meant that the default judgment was void and needed to be vacated. And as a result of that, the auction sale that was only allowed to happen because of that judgment was also reversed. Now, all that does is undo the judgment. That doesn't save her real life problem, which is that she has a mortgage, which is still behind, but she's got income, she's got a job, she's trying to get back on track. And so the final piece of the mortgage puzzle was helping her work with the mortgage company to secure a loan modification that rolled in her arrears, brought her current, extended her term, dropped her interest rate, and gave her new, fresh start monthly payments that fit her income and allowed her to be current going forward. Now, the one thing you might all still be wondering about is, that sounds wonderful, I'm so glad she's there, but what about this scammy law firm? What happened to them? And so I'll turn it over to Tom just to tell you for a few minutes about what he, together with a pro bono attorney, were able to do. There's only so much we can really say because a lot of it ended up being confidential, as you can imagine, but that was a piece where having additional help from pro bono and Tom working together with this attorney really helped to provide a much more holistic resolution to her problem.
Yeah, so after Jen and another legal aid colleague pulled a rabbit out of the hat and the minor miracle of getting this whole thing set aside in court, even after the sale had happened, and I heard about this story in our internal discussions, and my blood was boiling, as I'm sure many of you feel. I'm sure many of you feel the same way about these lawyers. And one other fact about the law firm she hired, it was really an internet law firm operating out of a office in Brooklyn. They advertised services on the internet focused on helping people get loan modifications when facing foreclosure, but also clearly offering to handle any court case involved. And their model was, they had a lawyer in the DC area who was admitted in DC, and the idea was, hey, if you get sued, that lawyer will handle your case. Well, as Jen suggested, not only did the Brooklyn lawyer that she retained not handle her case, her court case, but the local lawyer who really was supposed to be handling her court case didn't handle the court case, even though they were on notice of it, and even though Ms. Williams kept sending them copies of court papers that she received. So we recruited a pro bono attorney, Andy Marks, former president of the DC Bar, and also a legal aid servant of justice award winner, who happily agreed to take the lead on the potential malpractice claims, working with me primarily at Legal Aid. And as Jen said, the details of how it came out are confidential, but what we can say is that the case was settled, and it was a satisfactory result for our client.
So we have, I think we made it in time. I think we have a hard stop at 3 o'clock because of another Zoom meeting. So I want to invite people, if anyone has any last questions that they want to put in the chat box while we have just a couple more minutes, we're happy to answer them. And if not, I think we just want to say thank you for giving us an hour of your time to hear from us, to ask these questions, to learn more about our work. We really appreciate all of your support.